Good afternoon, everybody. This is Scott Hayslip, NAA's VP of Legal Affairs. I wanted to welcome you to NAA's webinar on website compliance under the ADA and the FHA. As everybody knows, this has been a growing area of concern for the industry as multiple lawsuits have been filed against several apartment operators across the country. So today you'll be hearing from two experts on this topic from the law firm of Blank Rome, Tony Mangione and Martin Krezelik. Just to let you know, they'll be presenting for about an hour, but feel free to interrupt with questions at any time. You'll have to unmute yourselves, or you can also use the chat function. And if there are no questions during the presentation, we'll also have time open at the end of the presentation as well for anybody that wants to ask questions at that time. So with that, I will hand it over to Tony and Martin.
Thank you, Scott. And thank you again to everyone at the National Apartment Association for setting this up. Aisha, much appreciated. And we'll jump right in. Today, we are going to present in hopefully interesting fashion about what we have as the top 10 questions and answers for 2020 in the space of website accessibility. To echo what Scott said, we have plenty of material to go through with everybody, but if there are burning questions that folks have, I got one in advance of the webinar today, so we will get to that one for sure. I appreciate always the enthusiastic crowd we get, and if the people want to send them or interrupt, by all means, we are here as a resource to all of you. I'm Anthony Mangione. I am a partner in the Labor Employment Group at Blank Rome. I go by Tony. I'm also the co-chair of the General Litigation Practice Group, and with me is my colleague Martin Krezelik, who is a counsel in our corporate litigation group here in our New York office. Just a few things about the Blank Rome team in this space. We have a nationally recognized ADA website and mobile app defense and compliance team. We have litigated cases across the country in this area, and we have a multidisciplinary approach to assist clients with compliance, litigation, and remediation. And most of these matters either are resolved in the compliance phase without litigation, or as we'll talk about a little bit later, litigations are generally resolved fairly quickly. So it's the rare case that goes the full distance, and we can be there for you every step of the way. Our lawyers have represented clients across the country facing these types of suits. We're recognized as thought leaders in this space. We've written numerous articles and been at various presentations on these topics. And again, we're here as a resource for all of you. We can also help with things like remediation, vendor selection, and insurance coverage questions, which come up as a result, oftentimes in tandem with the direct issues of the website compliance. So what are we going to talk about today? I said there are going to be 10 questions and hopefully answers. So we're going to start simple and get more complicated. So hopefully, if we start with a general and we get to a point, if you're hearing some of this and you say to yourself, I already know that, that's great. If it's one of these things where you feel like you already know it at the beginning, it may very well be that somewhere in the middle, we'll get to stuff you haven't heard before. So hopefully this is something that has a topic that's an interest to you personally. So we're going to talk about the laws. We're going to talk about what website accessibility is, whether there are regulations, how is compliance measured. We're going to discuss what's going on in current cases. What does this all mean as it relates to mobile apps? What's happening in the apartment industry generally and specifically? How do cases typically go? How can I prevent or defend a lawsuit? And then Q&A from the audience. So what are the laws? Well, there are a few that we talk about when we talk about website accessibility. The first is the one that people think about most commonly is the Americans with Disabilities Act. Prohibits discrimination on the basis of a disability in the full and equal enjoyment of goods, services, facilities. Basically, in this context, we're thinking about things that are open to the public accommodations, and whether a website is a place of public accommodation has been something that has been subject to a lot of litigation in this area But generally speaking, the answer to that is yes, with some finer points we'll discuss later. Also of particular interest to people in this group is the Fair Housing Act. And we're now seeing a wider proliferation of cases alleging violations of the Fair Housing Act in terms of website accessibility. The Fair Housing Act protects people from discrimination when they're renting or buying a home, getting a mortgage, anything housing related. There are also additional protections which may apply to those who provide federally assisted housing. We can talk about that, specifically offline if people have questions about that. And note that federal agency websites have additional regulations. The Rehabilitation Act is one of those, and airline carrier websites have specific regulations.
So we're going to start with the Americans with Disabilities Act. Like Tony said, the ADA prohibits discrimination based on a disability. So what is a disability for the purposes of the ADA? Well, the term under the statute means a physical or mental impairment that substantially limits one or more major life activities of such individual, a record of such an impairment, and being regarded as having such an impairment. Courts have held that the blind and visually impaired satisfies having a disability for ADA purposes. An individual meets the requirement of being regarded as having such an impairment if that individual establishes that he or she has been subjected to an action prohibited under the ADA because of an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. Second thing that Tony mentioned was that the ADA applies to public accommodations. Now, the ADA was passed in 1991 prior to the existence of the internet. It lists several specific types of public accommodation, websites not among them. But since every business has a web presence, the United States Department of Justice traditionally pursued enforcement actions against companies with inaccessible websites. That also extended to mobile applications in recent years. So that's where it started with DOJ enforcement actions. But in recent years, in the last 3 years in particular, we've seen an explosion of private ADA enforcement lawsuits with private plaintiffs playing the role of attorney general. And all these lawsuits are similar in that they accuse websites of being inaccessible to the blind and visually impaired. In 2010, the DOJ began a rulemaking process to come up with standards for what renders a website accessible. And this continued throughout 2014 and 2015. It took comments from the public, and the process was abandoned in late 2016 with the current administration. About that time, we saw a spike in these private lawsuits claiming that commercial websites violate the ADA. The DOJ supported these lawsuits initially by filing statements of interest. And in the past several years, the DOJ stopped doing that. So we're going to get back to the Fair Housing Act.
Yeah, so in addition to the ADA, there's the Fair Housing Act, as we said, has some regulation in this space. It covers most kinds of housing. People on this call are generally aware that exceptions to the Fair Housing Act include owner-occupied buildings and with no more than 4 units, single-family houses, certain religious and private club facilities. The FHA prohibits discrimination in housing because of many characteristics, including disabilities. So how does the FHA translate to website accessibility? Well, in a lot of ways, it's similar to the ADA, in most ways, frankly. The FHA prohibits making housing unavailable based on disabilities. The FHA prohibits discriminating in the services offered to tenants or prospective tenants. And among other things, the FHA prohibits making privileges unavailable to the disabled. So how do the ADA and the FHA interact in this space? Well, private versus public is a big one. One of the big differences is that the ADA requires a public accommodation, yes, a public accommodation, and the FHA can apply in less than public settings, inside of an apartment building. And for the purposes of a website, think of that as perhaps a tenant-only website, something where it is not open to the members of the general public, but it is a website, an intranet for tenants, perhaps a board, that type of website, of internet or intranet offering. That's important for this kind of a situation. The FHA also applies to things like race and marital status and other protected characteristics that obviously are not covered by the ADA, but those things are not implicated by visual disabilities. So that distinction is a distinction without a difference. There's also who enforces it. There are different federal agencies, but both of the statutes can be the subject of private party lawsuits. Other things about are reactive versus proactive in terms of when an obligation exists. That the FHA generally has an obligation that exists in the provision of housing, where the ADA may only have an obligation if somebody is trying to actually use a public accommodation. But for the purposes of understanding what web accessibility is required, in practice, we are talking about a distinction without much of a difference. So when we talk about website accessibility, what are we talking about? We are talking about accessible websites are those that can be used by sighted people as well as those with visual and other disabilities. Accessibility includes more than blindness. It's important to note that, because although people think about this in terms of the blind, if you're going through the trouble of making your website accessible, and for some of us that's more of an update than for others, but it would behoove you to make sure that you think about things, or your consultant or your web developer, depending on who you're using, thinks about auditory conditions, motor disorders, color blindness, and things like seizure disorders. But accessibility means accessibility for all. But here we're focused mostly on, the alligator closest to the boat, so to speak, which is visual disability claims, which are the vast majority of claims in this area. Visual disability claims, visually impaired individuals use what's called JAWS, or another screen reading software device, to access and read content on websites. But the software does not work with a defendant's website, or only works on certain portions of the site. That's usually what the claims look like. These are some typical examples. Things like images cannot be read because of the lack of alternative text, menus don't work, maps can't be comprehended, or video is not closed captioned. Other things that you see sometimes are problems with links not being updated, and a lot of times issues are with third-party content, when businesses either link to external sites or provide content created by others on their own websites. And we've seen situations where third-party providers, or where perhaps if you are providing content to advertise, an apartment, so to speak, or other lease offering on a website for a third party, you may get a request from that third party saying, you need to make your material that's going on our website accessible if you want us to keep advertising for your particular property. So that's a demand letter we've seen as well. So what is lack of alternative text? You can see here's an example. The image below does not contain alternative text. So a screen reader would just say image, because there's no text coded to tell the reader what to recite. Think of it like a picture of text rather than text embedded as text. Or here, the language selection drop-down is missing alternative text. And this would, all that would happen is that the screen reader would give basically what the JavaScript code is. And we've all seen situations where all of a sudden something that we were using became something that just looked like a series of code. And what would happen there is the screen reader would simply read out code and not what actually is behind the drop-down. So Global Accessibility Awareness Day is a thing. We've usually on Global Accessibility Awareness Day, we like to do a presentation. It's every May. We've done it May 2018, May 2019. But it's important because if you're thinking, what is this really like? This will give you some ideas about how to see how people with barriers access the internet. If you've tried this, doing it for an hour is very difficult, but just doing it for a few minutes, try to navigate the web with a mouse, try to actually use a screen reader or use a voiceover program.
So now let's return to government inaction in the ADA space. So there's a great deal of uncertainty right now about what to do if you're sued, and even if you haven't been sued, what you can do to reduce the risk to limit your exposure. The reasons for the uncertainty, as I previously mentioned, the ADA was enacted before the internet and doesn't say anything about websites. So what we have is a situation where regulation is happening through litigation. The courts are writing the rules, and they are not entirely consistent. There currently is a split among the federal circuits regarding, first, whether the ADA even applies to a website, with most courts leaning towards yes, and if it does, what it takes to state a claim under the ADA. There presently are no guidelines for website accessibility the way that there are guidelines for brick and mortar accessibility. That's left us with the state of uncertainty in the law. As mentioned, the ADA only discusses 12 particular spaces that qualify as accommodations. So courts are writing the rules on whether a website qualifies as a public accommodation. And right now, the biggest circuit split exists as to whether a so-called nexus is required between a website and a physical location. So courts in the First, Second, and Seventh Circuits, which encompass large city centers, Boston, Chicago, and New York, have suggested that that the ADA can apply to a cyber-only website without any connection to a physical place, because the website itself is the place of public accommodation. On a more conservative side, the Third, Sixth, Ninth, and 11th Circuits, covering Florida and California, have created something called a nexus requirement. These courts require the plaintiff to demonstrate that at a minimum, the website either facilitates the use of the brick and mortar location or connects users to the services of the brick and mortar location. A very prominent case called Robles versus Domino's went up to the Supreme Court. We'll return to that in a few minutes. Reaffirmed that the nexus requirement is alive and well in the Ninth Circuit. So the Department of Justice, as we mentioned, has abandoned the rulemaking process, at least for the short term. We do know that several senators have been writing to the Attorney General to clarify his position on the ADA and whether the ADA applies, and B, whether the DOJ plans on restarting the rulemaking process that it abandoned. And these senators are urging them to do so because regulation is necessary to provide a safe harbor, to show businesses what they need to do in order to stay within the confines of the law. Now, the uncertainty stemming from this government inaction is probably the key reason behind the explosion of cases that we've seen. It's easy to bring a lawsuit where there's a lot of gray area as to what it means to be accessible for ADA purposes. Many industry experts and lawyers were expecting the DOJ to do something to address this, but they didn't. What most people were expecting to happen is for the DOJ to adopt certain guidelines which exist. There are guidelines, again, we'll return to this later in more detail, but guidelines promoted by the World Wide Web Consortium, the W3C, called the WCAG 2.0 guidelines, exist as the minimal standard needed to make a website ADA compliant. Several courts have held this. The DOJ itself has worked the standard into certain settlements. So most people consider that to be the de facto prevailing standard of what it means to have an accessible website. It's based on criteria. Again, we'll get into the detail later. Other legislative and regulatory attempts that have Come up short is in 2017, there was an ADA Education and Reform Act. That did not make it to a final vote in Congress. I mentioned the pressure, the 2018 letter confirming that the ADA applies to websites. That was a response from the DOJ in response to the senator's letter. There has since been more correspondence on this topic, and I think right now the ball is in Attorney General Barr's court to respond to the latest letter, which the senators sent a few months ago. But to date, the DOJ has failed to endorse WEAK Act 2.0 as the standard, or any other guidelines for that matter. And based on what we've seen, based on the radio silence that we've seen, we don't anticipate anything happening in the near future, especially in this anti-regulatory climate.
Yeah, I think this would be a good time because we've gotten a bunch of questions to sort of jump off topic for a second and handle a few of those while Martin gets a drink of water and catches his breath for a second. We've gotten some great questions so far. So this will lead to us skipping around a little bit, but like I said, we wanted to hear from you also. Let's just take a few. So we have a question that does federally assisted housing include accepting payments from Section 8 subsidies? So yeah, generally that would be what we're talking about. There are other things, but certainly there are guidelines that are embedded in all the federal programs that people may be participating in. One of the questions, okay, so for providers of services to housing communities, how do you see the requirement of the provider's website having to conform to these same requirements? Do you view them as having the same or similar exposure in terms of legal action from a tenant or potential customer? Right, okay, so there's an example there. I think that sort of highlights the one big FHA ADA distinction. I think that the ADA applies to all places of public accommodation. So if you were to go and research ADA case law on websites or physical premises, you would see many times people have raised arguments saying things like, I'm not selling anything to the public, I'm a shopping mall. Oh, there's a bunch of old shopping mall cases where they say, wait, we're just a building, the stores are the ones selling things, we shouldn't have to comply. Generally speaking, open to the public is more than just selling to the public. But then you take it another step back where common areas of the physical experience of the common area of an apartment building or a common area of a co-op, places where they are semi-private and semi-public. Those are questions where it depends on the details. It's certainly one of those situations where you'd like to be able to give it a clearer answer, but certainly the fact that the FHA applies in private situations where the ADA only applies in the public, it may essentially bring us back to a distinction without a difference in the fact that both of those statutes, and this is something I maybe did not mention earlier, the FHA and the ADA, although the FHA uses the term handicap, the ADA uses the term disability, they mean the same thing in practice. So people who are covered by one are covered by the other in terms of their personal conditions. And then the question becomes, okay, well, is this a place of public accommodation? Well, that matters for the ADA, doesn't really matter for the FHA. So if one needs to comply with the FHA, one would be de facto complying with the ADA in terms of the substance of that compliance. What do we do about color-coded maps? Yeah, those are things that a color-coded map needs to have contrast so that colorblind folks can see the distinctions, and it needs to have the assistive technology to read the content of the map with a screen reader. Are the same website laws also in place for email, such as email marketing campaigns? Another great question. The answer to this is, again, it depends. I hate to make that as an answer. I remember when I graduated from law school too long ago, the graduation speaker said, 3 years ago you sat here, I could have asked you a legal question and you could have with all honesty answered, I don't know. And now 3 years and hundreds of thousands of dollars later, you could answer the same question by saying it depends. Neither one is particularly helpful in a specific situation, but really in this case, it really depends on whether these targeted approaches are to the public or not. Although I would say an email, if it's just text, a screen reader can read the text of an email. So a targeted email that is itself either written in with accessible, with just plain text, or with accessible coded pictures and other things, wouldn't be a problem, even if compliance was required. All right, so that was a 5-question break. We'll skip back into it, and then we'll go back and take a few more questions.
So with the federal regulatory vacuum, some states have tried to come up with their own way of dealing with this issue. For example, last year, May of 2019, the New York legislature announced that a state Senate committee was formed to develop legal standards for accessibility for business websites. And we haven't seen anything passed yet, but we're skeptical that even if it does happen, we're not sure it's going to make a difference, because state laws generally do not affect remedies under the federal ADA. We mentioned the nexus requirement. That's probably the biggest geographical difference in terms of how states are approaching these types of lawsuits. So we'll talk about New York for a minute, because that's where we are seated, and we see many cases here in New York. In New York,
and Martin, not to interrupt you, we got a New York question, so this would be a good time to go back to the question.
Sure.
New York does. I'll ask it to you. Does a New York City reasonable accommodation policy go further than the federal laws?
It does, and we'll cover the New York specific laws in a few minutes. We've got New York state laws, and we've got New York City laws that apply to civil rights that are often brought as tag-along claims in these types of lawsuits. But on a federal level, several cases have held in the federal courts of New York. In the Eastern District, legendary judge Jack Weinstein had a decision a few years back that went against Blick Arts, a website art supplier, that essentially said that cyber-only websites are places of public accommodations. There need not be a connection to a physical location. There's been several other decisions that have followed up on Judge Weinstein's decision. We have seen some positive developments. We'll return to those later when we talk about potential defenses that one can raise to these lawsuits. But New York has set itself apart because it was one of the first places to hold that there need not be a connection to a physical place. So in New York, a website like Netflix or eBay could be subject to the ADA, whereas in the Ninth Circuit in California, they're not. As a matter of fact, let me use Netflix as an example. Netflix was sued on an almost identical complaint, almost identical theory in California and in Massachusetts, First Circuit and Ninth Circuit, with both cases months apart, going in opposite directions. In California, Netflix was not a place of public accommodation. In Massachusetts, it was. So that's just an anecdote as to how the jurisdiction matters. Same claims, same defendant, different result, months apart. Somebody brought up the New York City law. So generally, state law disability claims mirror the federal ADA claims, and in terms that both target discrimination in places of public accommodations. However, there are several key differences between federal and state, primarily in what relief and damages are available. So going back to New York, the New York human rights law permits not just injunctive relief like the ADA. The ADA is an injunctive statute. What you can get out of the ADA is you can get the defendant to fix what needs to be fixed, to quote unquote stop discriminating. But in New York, you can go for not just injunctive relief, but also recovery of money damages. And that makes a big difference in terms of how to defend these cases and how quickly defendants settle and your exposure. And there are also civil penalties. The California Unruh Act, the notorious Unruh Act, also permits monetary recovery per violation.
Right. So to answer, we've had a few questions for skipping to New York specific laws. So I think um, as Martin said, there is some specific differences for New York, which we have in a little bit more detail.
Right. So on the next slide, we drill down on some of the differences. The New York State human rights law and the New York City human rights law, statutory penalties of $100 to $500 for each and every violation. So in a website context, that means each visit to the website. The New York City human rights law on top of that allows for punitive damages. You can get even more than just the per website damages. We have not seen any damages awarded under these statutes, but we are seeing many of these claims accompany ADA claims in these lawsuits.
Right, and they usually have the effect of jacking up the monetary ask to resolve the case.
Right, and they're easy to intertwine because a violation of the ADA is necessarily a violation of the New York State and New York City human rights laws. Now, somebody asked about the scope of the New York City law. Yes, the New York City law is broader than the ADA. It extends to providers of public accommodation, not just places of public accommodation. That could be a key distinction. So courts, when we see decisions analyzing these cases, there's usually a separate section that the court devotes to analyzing New York City human rights claim. Even if the challenged conduct is not actionable under the ADA or the state law, the court must separately consider whether it's actionable under the New York City human rights law. We mentioned California's Unruh Act. Just like the New York civil and human rights law, a violation of the ADA is also a violation of the Unruh Act. The Unruh Act is broader than the ADA because it extends to business establishments, not just places of public accommodation. It's easier to fit in within that confine. It's backward looking. So mootness may not be a defense. We'll talk about defenses later, but mootness may not be a defense to Unruh because the Unruh is backwards looking. So even though you fixed it today, my visit to your website 3 weeks ago is actionable, and it's $4,000 a pop. The Unruh is slightly more conservative because intentional discrimination is required under Unruh, unlike the ADA. However, that concept goes out the window because a violation of the ADA is also a violation of the Unruh Act. So long as you plead that, so long as you can plead in your complaint that defendant violated the ADA, you also by extension violated the Unruh Act. Nobody brings claims for just violations of the Unruh Act. And also, just like New York, you've got statutory penalties, you've got attorney fees, and injunctive relief.
All right, so this will bring us to the next sort of question number 4. How is compliance measured then? We've spent a good deal of time talking about how nothing is really clear or everything is sort of, the deck is stacked against folks. I think this will get to a lot of the questions I've seen popping up. So I'm gonna try to get to a bunch of those here in this section. But first, let's talk general, and then we'll answer some compliance type questions. So, you know, there is no comprehensive standard. You may have heard of what we're going to talk about next. A lot of people from their questions would suggest that they have, that many businesses and many courts and many attorneys look to the Web Content Accessibility Guidelines. What are the Web Content Accessibility Guidelines? Well, there's an entity called the Worldwide Web Consortium, W3C. It develops international standards for the web. They have an accessibility initiative that develops standards and support materials to help people and businesses understand and implement accessibility. They also provide resources to make websites, apps, and digital content more accessible. They also provide suggested guidelines for website accessibility. The guidelines provide instructions and specifications for web developers to design and modify websites for people with visual disabilities and other disabilities, as we discussed earlier. These are recommended international web standards. They are not required. They have been widely accepted and followed, including by various courts. But sadly, being able to show that one is 100% compliant with this is sort of like having a car alarm or a security system at your home. It makes you a less attractive target, but a determined plaintiff's attorney can still proceed with a lawsuit against any business in this under that theory. But it is the best measure we've got to measure compliance.
I would just add that while the guidelines have no independent legal significance, the DOJ has applied these guidelines in the settlements that it has reached with defendants. So when the DOJ was active a few years ago in going after inaccessible websites, when it reached settlements with defendants, it forced them to apply WCAG 2.0 as the criteria for making the website accessible.
Right, and also this sets the standard to which the federal government holds its own websites. So what is web accessibility? How do these guidelines work? Well, there are several components. One is web content. That's any part of a website: text, images, forms, multimedia. And then there is something called user agents. Those are basically, that's anything people use to access the content, whether it's a browser or a multimedia player and some assistive technologies, that sort of thing. And authoring tools. Those are software or services that people use to produce the web content. The idea here is that the components work in concert, that web content needs to include accessible alternatives for visual components, such as the alternative text that we discussed earlier. That material is then processed by some user agent, like a browser, and then conveyed to an assistive technology like a screen reader. All of this can only be accomplished with the help of authoring tools designed to foster accessibility. Okay, so another question break to discuss some of the questions that came in on these topics. Let's see, so one question is, isn't 2.1 the current standard as of 2018? Let's talk a little bit about WCAG, we call it the WCAG, WCAG 2.0 versus WCAG 2.1. Okay, so there are a couple things. Because the WCAG are guidelines, in a way, WCAG 2.0 is going to be frozen in time as the standard in a lot of places, even though the WCAG people have, or the W3C people have developed new standards. And why is that the case? Because in the legal system, we rely on legal precedent and regulatory decisions. Those have held up the WCAG 2.0 standards as those standards to which one must aspire. So that this is an example of art and life not necessarily imitating each other, whereas although the W3C has come up with new stuff, it's not universally accepted by the legal community the way that that WCAG 2.0 has been. Now, if you're 2.1, you're 2.0. It's not like they've changed anything that to make, well, I was 2.0 and now I have to do something, that would be inaccessible under 1. It's sort of like, all squares are rectangles, but not all rectangles are squares. If you're WCAG 2.1 compliant, you're going to be 2.0 compliant. But 2.1, that's the legal side of it. The other part of this is, practically speaking, 2.1 also, most of the changes it makes are to the app space. So things like, things that apply to those apps, things like display orientation or pointer gestures and motion actuation. There are things that there were, I believe, 12 WCAG 2.0 guidelines, and now 12 general categories, and now 2.1 increased that to 17, but the 12 are still the 12.
Just going back to the legal side, we've seen several decisions where WCAG 2.0 was adopted by the court as the injunctive remedy. We've only seen one decision in California where WCAG 2.1 was adopted, and that was against a public entity. It was some sort of government website in the state California government website. We have not seen WCAG 2.1 adopted as a remedy against a private entity yet.
Right. So let's see some more of these questions, which I think would apply. Are we liable for Facebook images? Facebook puts all text automatically, and what happens there? So Facebook images, if your material is on, generally speaking, the person or entity that owns the domain name is responsible for the content on that website. That general paradigm can be altered between the various parties to the agreement. For example, I have a website, I outsource the development of that website to a third party. Although I can outsource the function, I cannot outsource the responsibility. So Facebook is responsible for what Facebook puts out. You, the various website owners, are responsible for what you put out under your domain names. If somebody else provides content that they tell you is compliant and it's not, your remedy would be against them, but the disabled person, that does not affect the disabled person's remedy against you for violating the law and what you put out under your own domain.
Right. The ADA is limited in that it applies to operators. This is the text of the statute. The ADA applies to a party that either owns, operates, leases, or leases to a place of public accommodation. So to tie a party to the website, you have to establish one of those things. You have to be the operator of the website. You have to own the website. Facebook itself gets sued for website accessibility because it operates that website.
Right. So another question we have is it possible that the reason the use of code is in place on website functions as opposed to the vocabulary in the drop-down boxes is to protect against hacking or viruses? The thing about that is that may be the case, and having a good reason for something that's otherwise discriminatory, and I don't use the word discriminatory lightly, but having a good reason is, in the legal parlance for that, would be an undue hardship or undue burden. So if somebody, I'll use this in an example that is not from a website case, but I think everyone could understand. Let's say you own an old apartment building with a parking garage, and the roof of that building is short, and you have a clearance in that building that just cannot accommodate disabled vans, okay? If you get sued for not having a disabled van access inside your garage, there are two things that you can do in that situation. One is you can offer something which would be an accommodation where it would not, people wouldn't be parking in the garage. But the other thing is, if there was no option, you could have a hardship defense and say, look, it would be so expensive for me to fix this that it would create an undue hardship, and therefore I should be excused from this particular thing. Now, if there's some case where I have not seen this, and Martin, I don't know if you've seen it, jump in on this. I haven't seen anyone make the case yet that they could not do accessibility because of some concern about hacking or viruses or the like. No. So now, if someone could put forth a defense at some reason that would be the case, that's something a court would have to consider, and it would be a legitimate defense. If you have video of a walkthrough in an apartment that has no sound, what should be done? Well, this goes to obviously if there's sound, closed captioning is great. But if there's a picture, I mean, it's the same thing as a picture. A photo has a descriptor. So if it's a picture of an eagle, it could very easily say, the screen reader, when the person accessed the photo, it might say, this is a picture of a bird. It might also say, this is a picture of an American bald eagle. It might say, this is a picture of an American bald eagle with white feathers, brown feathers, a yellow beak. There has to be a description, and that is something that the developers of the websites can work with to come to some understanding of what is sufficient detail to describe that, so that the person, the ADA does not require quality of access, it just requires reasonable access. Okay, so here's a great question from Monica. Is there a way to test your websites to ensure they are compliant? Now, it's funny, we're going to talk a little bit about vendors later, although it's getting later earlier these days, as Yogi Berra would say. So let's just jump right to this particular point. The quick answer to that is yes. The short answer to that, the somewhat longer answer to that is be careful. So Google does have a tool in its web browser which will check accessibility for you. I strongly advise you to both use that tool and not to trust it completely, because there are several layers of compliance, and the ADA has what's called a mootness defense. We'll talk about defenses, but mootness is basically to say if this was an issue before, it's not an issue now. So there's no reason to sue me about it. So if one were to sue and say, and we've had this case where someone sues and says your website's not compliant, and we respond and say, whether it was compliant or not when you wrote us this letter or sent this lawsuit, it's now compliant, so go away. And a lot of companies will call us, and the first thing they say is, I ran the Google Chrome accessibility tool and I got a perfect score. That's great. But that's only about, that tests for only about 30%? About
30%. This ties back to the WCAG 2.0 criteria. So those online testing tools, and there are several others in addition to Google. The Google one is probably the most often used, but that will cover about 30% of the WCAG criteria. So if you get a good score, that's terrific. But by no means does that mean that your website is fully accessible and immune from a lawsuit.
Right. So if you have a Google score of 20%, that's bad. If you have a Google score of 100%, that's good, but it's not outcome determinative. There are basically 3 layers of this testing. There's the freeware that I mentioned, the Google one. There are other specific apps and softwares that you can get for free that will generally test your website's accessibility. Then there's proprietary paid for software, things that people on both sides of these cases use to test websites electronically. Basically, that's the stuff that we'll say the bad guys, quote unquote, use to find defendants to sue. They use software programs for a lot of that stuff. And then, so that's a little bit more detailed. But then there are, the third level is manual testing by an actual blind or visually impaired person to actually try to navigate the website. So is there a way to test? Yes, there are several ways to test. And as you may imagine, as you move along that scale I just described, you certainly get more expensive. So this goes to Brian's question, which was the next one, which is, I noticed on Google Analytics I had a spike of users at odd hours a month apart for the last few months. Is this a bot combing my site for compliance? It could be. I mean, that is the kind of thing that they do. Obviously, the bots will run faster at times of day when there's low web traffic. So that's the time that they'll run these bots. Or, it could also be that there's people who are like insomniacs are looking for apartments in big droves. But in all likelihood, it may not be that kind of bot, but it's probably some bot doing something. So let's see. Does this apply to property managers or aggregators reporting rent payments to credit bureaus? I mean, look, the short answer is these laws apply to everyone. If we're just talking about private party transmissions, where someone is sending something to someone else, then the actual transmission of payments, then no, it wouldn't apply to, if I send Martin an email about our job and I send him a PDF of a legal brief that we're working on, that does not need to be compliant with the ADA and visual disabilities, because it's not being offered to the public. It's a private inter-law firm communication is by far one of the least public things that's out there. But to the extent that those entities have tenant-facing or public-facing products, then yes, they would need to be compliant. Let's see. Does Instagram social media come under the same scrutiny? Again, like, these are things where it really depends what is the context. A business's Instagram feed or a business's Facebook page is not as public as its website if you have to subscribe to it. But this goes back to the FHA distinction. For the people on this call, if you're talking about providing services to tenants, doing so with a Facebook group of your tenants or an Instagram feed for people in your, co-op or whatever, these are things that may run afoul of the FHA, even though they may be in spaces that the ADA doesn't touch. So this then goes to if my apartment building does not publish its own website, but uses a third-party website, do we have a responsibility to make sure those websites are compliant? So it depends. If you're talking about content that you've provided, then you may have a responsibility. Your responsibility may be to the website to whom you've provided that content. Certainly Craigslist, certainly Apartment Finder, like those websites have a responsibility. They are the ones who own their content. That is something that would be sorted out among various co-defendants, but it may not be something that can get you off the hook for direct liability to the visually disabled person. But again, the devil is in the detail. The devil is in the details there. So another question about content, then back to the photo question. Does this mean, from Courtney, does this mean that the naming of the photo is the description the screen reader would read? Generally, yes, but it also depends. You could, a web developer can make a more descriptive description. So it just depends on the behind the scenes content can be as simple or as complicated as it is loaded on the web. Virtual tours, again, similar thing. I would suggest that we have captions, closed captioning if there's sound, even if it's music, to say there's music playing, or soft jazz is playing in the background, and a description, this is a virtual tour. But that really becomes devil in the details a little bit.
If you, for example, use an online platform such as Shopify, you are operating that website. You are creating the content for your own business. Even though you're using a third-party platform, you would likely be liable under the ADA.
Okay, so all right, there's a bunch more questions, and that's great. We're going to switch back to the materials and then come back to some more questions, because we want to talk about what's going on in these cases right now. There's been a tremendous increase in the number of cases that are being filed accusing companies that operate business websites of violating the ADA. A particularly high increase of cases in New York City, in California, and the Southern District of Florida. I saw someone asked a Florida question. The issue with Florida is not that the state laws of Florida are particularly different. It is that Florida is right now the only place where one of these cases has actually gone to trial. So that's something that we'll talk about in a little bit, but basically the result of that trial was an order of compliance with the WCAG 2.0 guidelines. No industry is safe. Any entity with a website is at risk. What's going on in this industry? The apartment industry has not been immune. According to UsableNet, the real estate agencies and properties are the 6th most commonly targeted businesses in website disability discrimination cases, and hospitality as an industry is 4th. And so, considering these two together, only the retail industry gets sued more. Why target the apartment hospitality industry? The proliferation of consumer and customer-facing websites. The sites are complex and thus difficult to keep accessible. Many businesses have multiple websites, which adds to settlement value. Again, domains, a lot of apartment buildings and property managers have separate sites for each property. Each domain, each subdomain could be a different suit. Sometimes these correspond to different corporate entities or different limited liability companies that own different properties. Each one of those is responsible for its own thing, and you end up having one business entity that has 16 websites that get all lumped into one lawsuit. Then plaintiffs' lawyers are used to suing these entities in physical accommodation cases, either FHA or ADA, and they know the players and they think that businesses will settle easily.
And we have defended defendants in this space on several occasions, and we can tell you that the same serial plaintiff and same serial plaintiff's lawyer often file identical complaints against several different properties, several different websites operated by the same defendant. The complaints are very similar in that they all allege that the defendant owns and manages the building, that there's a website which is heavily integrated with the building and serves as its gateway, and that's for the purposes of meeting that nexus requirement I discussed earlier, and that the website is not accessible. Our experience with these plaintiffs and their lawyers is that the plaintiffs pick an area of focus, usually by industry. We see lots of lawsuits grouped together by industry. So wineries will be targeted on one day, craft breweries another day, colleges the next day. It seems that the plaintiff's lawyers compile a list of industry participants, and then they run tests on the websites to check their level of accessibility. And in some cases, they follow up with a manual review, which is a deeper dive. Sometimes they send a demand letter. Other times they go right to court and file a complaint.
All right, that's a question we did have in the first. I know I was holding that question for now.
Right.
Someone had asked, and I apologize, I don't remember who it was, had asked, well, how do these things, do they start with a letter or do they start with a lawsuit? And the answer to that is yes, they can start with either one, as Martin said. I mean, usually they're both efforts to get to the same thing, which is the plaintiffs look for someone to respond, and they're looking for someone with whom to negotiate.
Right. The vast majority of these cases settle in the early stages, and this is a product of cost-benefit analysis. It simply put, it just costs more to litigate these cases than it does to settle early. So we call them shakedown lawsuits. We call them sue and settle lawsuits for a reason. Only one case that we know of thus far has gone to trial, and that's the Winn-Dixie case in Florida that Tony mentioned earlier. That case resulted with the judge ordering Winn-Dixie to come into compliance with WCAG 2.0. That case is now on appeal. It has been argued before the 11th Circuit, and we are eagerly awaiting the decision. Hopefully that will set up a circuit split, and the Supreme Court may have a reason to take the case next year. A few cases, we've seen some bright spots. A few cases have been dismissed. We've had a few victories on motions to dismiss. The best place to try to get one of these cases done and over with is to file a motion to dismiss before getting into costly discovery. That's when the legal costs are still low enough to warrant fighting. We've had several clients fight these on principle, meaning my website is compliant. We've devoted money and resources into making the website compliant, and we refuse on principle to settle with these guys. We're seeing class actions. The ones that settle before the class is certified, that's probably the most common example. So a case is a purported class action, but it settles early, so it never becomes one. Most settlements are confidential. There are certain circumstances, and we've employed this, where a consent decree is filed on the docket, but usually the monetary terms are confidential. Let's talk about the unintended consequences of these lawsuits. The plaintiff's lawyers and the plaintiffs will tell you that they are doing good and there are no negative effects. That's not the case anecdotally. For example, certain city agencies have shut down their websites out of fear of being sued. Last year, Manatee County in Florida was sued and they settled. So neighboring Bradenton Beach took down its website. Why? Because they were afraid of getting sued. Who wins in that circumstance? Certainly not the residents of Bradenton Beach. We've had clients tell us that, look, I'm thinking about taking my website down. I don't want to be a target. Who wins in that circumstance?
So how do we prevent and defend lawsuits? And let me say this, there were a couple questions that we got, and I saw Jeffrey saying that we were in the middle of answering a question of his when he lost our contact. So I don't want to give him short shreds. I think we were talking about commercial real estate offerings versus residential real estate offerings, it's important to know that the FHA is not going to touch people in the commercial space, but the ADA may, if the website offerings are open to the general public, even if it's a commercial offering, it is still a public accommodation, and so there is still a risk of suit. Again, it's lower because it's not as, the more your website is of a company that people have heard of, and we talked a little bit about how these lawsuits get in front of defendants, and usually someone will say, hey, we need to, let's look at hotels. There was a big hotel rash of cases, and now there's a big, if people follow this up, there's a big Braille gift card lawsuit, a spate of those lawsuits being filed in the retail space. So we hit all the retail websites. How else can people sue a retailer? Braille gift cards. So these are the kinds of things, if you're operating a commercial business-to-business website, it is not as likely that you will be discovered, so to speak, for a lawsuit, but certainly at some point, everyone ends up having their industry touched on it, and it just takes, someone deciding that they're gonna look towards the players in that space. So how do we prevent and defend lawsuits? You assess whether websites are accessible to screen reading software, devices, etc. That's like the various stages of self-analysis we talked about. This is, a lot of these things will be things you do even if you've been sued or you want to avoid being sued or you got a demand letter. These are sort of the same action items. Take whatever steps are necessary to make websites accessible. Determine whether to conduct remediation in-house or go through an outside consultant, and we'll talk about the pros and cons of that in a couple minutes. Develop and post an accessibility policy on your respective websites. That's the analogy to the, this home protected by SimpliSafe or something to that effect. A compliant website is good business. Remember that access to business websites for the largest number of consumers is a good thing, and the largest number of people is a good thing. Consider a hotline, consider an email address for people to relate to accessibility, accessibility issues. Why would you do this? Well, not everybody who's visually disabled who accesses your site is doing so because they want to sue you. They may also just want to rent an apartment. And it also is a good thing to turn to a court when someone says in a settlement or consent decree or defending a lawsuit entirely, we care about accessibility. It's a relatively low cost thing to do and easy to say, here's some evidence of the fact that we care. If you have an issue, call. And by the way, this person, there's a lawsuit involving a theater where the case was dismissed in part because the person, the purveyor of the theater had a hotline, had a place for people to go with accessibility issues, and the plaintiff didn't take advantage of those opportunities and just sued. And the defendant was able to defend that lawsuit by saying, look, we care, we tried, this person didn't have any intention of actually using our theater. And in fact, rather than call us to see what they could have done to be accessible, they just sued. So there are some really good reasons to publicize your accessibility efforts. And look, you should get credit for the good work that you do. If you're doing that stuff and it's there, you should be able to trade on that accessibility. Don't overlook your apps. Make sure third parties who run or contribute to content portions of your website make their content accessible. Obtain indemnification and other helpful clauses and contracts with developers, managers, and other vendors, and we'll talk about that in a little bit too. Keep online job applications. Retain the records. If you have those hotlines, you should make sure that you keep logs of who calls and when. It's no good, it's not going to defend you in a lawsuit if you don't have the records to show that the person never called or never emailed. So a few words about vendors. Vendors are available at various price points. They have scalable solutions. We talked about the various kinds of things that vendors can do for you. Automated evaluations, manual testing. Those things can cost more or less. We at Blank Rome have relationships with several vendors who provide various levels of service. at various costs, whether that's help us with this lawsuit, help us with an ongoing compliance program, give us a certificate of compliance. Again, that's just a piece of paper that can be used to defend as evidence of a defense. No one should think of that as a panacea. It's not a cure-all for all the potential lawsuits that could be out there, but it is, again, makes you not necessarily low-hanging fruit. One of the other things that you may want to think about is indemnification. A lot of vendors will provide indemnification to you. They'll say, look, you know, we will defend you. We'll pay for the costs of your legal defense if you hire us to develop your website and you end up getting sued. Something to explore. We can tell you, and Martin and I have priced out a lot of vendors, and correct me if I'm wrong, Martin, but the indemnification is not cheap. It is not something we'd recommend for everybody as a matter of course.
Right.
Right, but it is a service that's out there. If you have a large enough operation, it may be something you want to consider. Consider third-party liability. Obviously, if your in-house team is doing your web developing, then that's probably not something that's going to be available to you. But we also get a lot of clients who say, wait a second, I hired somebody to build me this website, and you're telling me that they built a website that doesn't comply with the law? And the answer to that sometimes is yes, and then the rights and remedies as and among developers and businesses will be determined by the contract language between them. So if you're hiring a vendor or a web developer, you need to have your legal representation look at the contracts and the statements of work, whatever the documentation is, to make sure that you assign the liability for this stuff where you think it belongs, and where, or at least if you know what you're getting when you pay for something that's the less expensive or the more expensive version. And then different vendors provide different levels of ongoing maintenance. There are certainly Cadillac plans, which are extremely expensive, which involve regular manual testing and all bells and whistles, right down to the, I'm only going to run an automated test to make you, you know, less findable by potential plaintiffs. Those are all things that are possible from a vendor in this space. We had a question about insurance. You know, a few words about insurance. Policies do exist to cover web accessibility lawsuits. Coverage may also be available under existing general liability umbrella policies as well. There are certain technology policies. There are riders of anything and everything. There are very many different policies which were written and signed before these lawsuits existed or before people sought to have coverage for them. So depending on the age of your policy, you may have coverage in a spot. I mean, the easy answer is you should, if you get sued, insurance coverage is something that you should be looking at as a possibility for how to decide, you know, how to manage your portfolio, how to manage that case, whether it's something that you think you need, you know, you need to raise when you renew your policies or in connection with the litigation. And we, you know, a shameless plug for Blank Chrome's policyholder practice is something where we represent insurance policyholders in any manner of coverage disputes against insurance carriers when they decline coverage. If you get sued, do not forget to check for coverage. So some more best practices, right? Companies should take whatever steps are necessary to make their websites accessible. It's good business. You want everyone to be able to access your site. Having an accessible website will reduce, if not eliminate, exposure for future claims. If you're sued and settled, you may have a mootness argument if you're sued again. You've got to consider strategies for making this the only lawsuit. Now, one of the things that we see a lot of in this area is the recidivists, the repeat offenders. There are strategies to avoid being a repeat victim. They include generally things like getting the plaintiff's attorney to buy in terms of having the plaintiff's attorney agree to sort of stave off future lawsuits by trying to, you know, the honor among thieves. Hey, these guys are under an agreement with me. Some jurisdictions will allow, if you have a settlement that is part of a court-ordered consent decree, an order requiring compliance, that you will have protection against suits while that is pending. That is not a lot. That's not the case in some jurisdictions. I think Florida is one of the ones where that's not a complete defense, which is why, going back to the earlier question we had about Florida, why a lot of suits happen there is because the plaintiffs don't risk as much with a mootness argument there if you're under a pre-existing settlement. But there are things that you can do to get, and interestingly enough, we're also seeing in some cases plaintiffs' counsels and looking for an agreement by the defense to allow the plaintiff to continue monitoring your website to do regular compliance checks. Most clients initially think that that's very offensive and want no part of it. What I will tell you, though, is that they can do that anyway. You can't stop people from reviewing your website because you're putting it out there to the public. And so they're going to do that anyway. And having that in an agreement, especially if, and we've seen this, the plaintiffs, this is usually the case when the plaintiffs are not individuals, when they are organizations dedicated to the advancement of the interests of the disabled. They really are interested, the true believers are interested in compliance. They sometimes just want to make sure that if they have an issue, the process is they send you a letter, they say you should fix this. They're not asking for more money, and that's really the key. People have told us if the plaintiffs are not asking for more money, they don't mind agreeing to future monitoring from plaintiffs because it becomes a symbiotic process. Yes, it's annoying to get letters from people who say, you added a new walkthrough video and it's not compliant, but at least you're not paying thousands of dollars to settle another lawsuit.
Okay, so we're getting to the end finally. Few key points, few takeaways from our presentation. One is that remediation is probably the most important thing. Like Tony mentioned, it's good from a risk management perspective, and it's just good business practice to allow everybody to use your business. If you do get sued and you want to fight the lawsuit, defenses do exist. I know we mentioned that it's difficult to prevail, but it's not impossible. We prevailed many times. Several particular defenses exist, two of which are based on the standing doctrine. Mootness, which I think Tony alluded to earlier, is a doctrine that says, look, if a federal court cannot grant you any relief, there's no case to be had here. And mootness exists in the brick and mortar context. Just a quick analogy. If somebody sues about an inaccessible staircase to the store and you fix that staircase, the case is moot. You were granted the relief that you sued on. In the website context, it's a little more difficult. It's grayer because, like we mentioned, it's difficult to gauge what is accessible. However, defendants have prevailed on mootness defenses on a basis that after I was sued, I retained a vendor. The website was brought into compliance under WEAK Act 2.0. Here's an affidavit from the general manager or from the CEO saying, I'm going to keep it in compliance. I'm going to make sure that this vendor monitors the website on a quarterly basis or whatnot to make sure that it stays in compliance. The case is now moot unless the plaintiff can counter that somehow with its own affidavit. There's also the defense of failure to plead a particularized injury. There was a good decision out of the Southern District for Apple last year where the plaintiff alleged that there was a flaw in a website that prevented people from making an appointment, that prevented users of JAWS and the types of readers that we discussed earlier from making an appointment at the Genius Bar at Apple. However, the plaintiff failed to plead that she even owned an Apple device or what type of device she was trying to get service. So the court threw the case out on a motion to dismiss, saying you have to plead an injury that's particularized to you, not to the world at large. And another defense that likely will apply to the industry on the phone here, personal jurisdiction. So let's say you operate a website providing information about a luxury condo in Miami. Can you be sued by a resident in New York who's trying to access the website and it's inaccessible? Two recent decisions serve as great anecdotes here in New York, decided on the same day, two different judges, but both decided on the same day, going two different ways. So personal jurisdiction based on websites is very particular. Courts apply something called the spectrum of interactivity test. How interactive is your website? So on the one end of the spectrum, you've got passive. A passive website merely provides information about services or contact information. There's no ability for the user to purchase anything through the website. In that case, passive website, no personal jurisdiction. In the middle, you've got interactive websites that permit some sort of exchange between the user of the website and the defendant, where there's an interactive website, the court has to dig a little deeper and look into what the level of that exchange is. Personal jurisdiction does exist if the defendant engages in purposeful activity towards the state. So in my example, if the defendant in Miami engaged in some sort of purposeful activity with respect to New York residents, sending someone to New York or something like that, there may be personal jurisdiction. On the far end of the spectrum, there's a highly interactive website which knowingly transmits goods, sells stuff or services to users in other states. There you've got personal jurisdiction. So the two cases I mentioned were both against universities. I think they serve as good examples. I think there's some analogies here. One was against the Ringling College of Art. New York resident sues them. The website was somewhere between passive and interactive. It provided information, but it also was promotional, promoted the college and the courses and things that the college offered and advertised the college. The court held that there was no personal jurisdiction because it did not specifically target New Yorkers. The website was a service offered throughout the United States, including New York. There was nothing New York specific. The mere fact that New York residents could access the website is not, to recruit students, is not enough to confer jurisdiction. And the case that went the other way on the same day was against Vanderbilt University in Tennessee. There, same thing, website was middle of the spectrum. It was interactive. And the reason that Vanderbilt lost here, the website included a net price calculator tool, which allowed the prospective student to put in information about themselves and get an estimate on how much financial aid they would get if they were accepted to Vanderbilt. Personal jurisdiction existed in that case. And those are two anecdotes that may apply to the apartment industry, depending on how interactive your website is, what sorts of tools are on the website that the user can use to find out information about the apartments.
Yeah, so I think, look, the takeaways are that inaction can be costly. Now, I know the site is still open. We got a bunch of questions in queue. We're happy to stick around and answer those. One of the first ones is a question about the United Africa Asian Abilities Club in Southern California. They're a prolific filer of ADA disability lawsuits, visual disability lawsuits. I mean, look, they're not any different than anybody else. The strategies, in terms of strategies we've discussed, obviously, it just depends on how much people want to fight. Like, litigation on principle is a service that law firms are happy to provide. Whether you have an effective defense strategy, of course, depends a lot on the specifics of your situation. A lot of these large-scale entities who are looking to file these lawsuits are looking for quick settlements. So it just becomes, how much of a fight do you want to put up versus what's the bid and what's the ask? Now, I promised at the beginning we get to our pre-question. I'll put it to Martin. The question we got is from Vito, and he wanted to know if a parent company who owns a property could open a wholly owned subsidiary for the sole purpose of operating the parent company's website. And would that insulate a company from liability? And if so, to what degree? By the way, that's a great question. And I really was like, this is a great, I like the way you're thinking, Vito. What do you think, Martin? Would that work?
Yeah, Vito, that's a multi-layered question. The short answer is probably, so long as you respect corporate formalities. The defense, I mean, the only way that a plaintiff could get to the parent would be to pierce the veil. So long as you observe corporate formalities for that sub, only the sub could be held liable. If the sub is indeed the operator and a parent does not have its hands. Again, you have to own, operate, lease, or lease to the place of public accommodation. So assuming the website is the place of public accommodation, if the owner or operator is the sub, that is the properly named defendant. And if the plaintiff names the parent company as a defendant, I think the parent company has a defense on the basis that you sued the wrong company. We've had this happen, by the way. The way that these things usually end is that informally, the plaintiff will drop the case and find the right defendant to sue. So we haven't gotten as far as getting a decision on this, but we've had situations where the wrong entity was sued.
Right, and if that were to go all the way, if the order of compliance that a court would issue would be something that the cost of which would be borne by the parent, it may be a Pyrrhic victory, but it could be victory nonetheless. So we have some questions. What happens if people come in with felonies looking to rent? And that's sort of outside the scope of visual disabilities, but a question we get a lot in the apartment context. That's a state-by-state question. Happy to discuss it with folks offline if they want to reach out to us later. But generally speaking, different states have different rules about what are appropriate reasons to deny someone access, and in what particular situations. It may run afoul of Section 8 as well, depending on what kind of housing it is, and if there's someone could make a race discrimination or other discrimination argument that the conviction or the eviction is a proxy for something else, that could subject one to other liabilities. Do we have a sample standard accessibility policy for websites that we're able to share? We've worked with many clients. Everyone's accessibility policy is different. We are certainly more than willing to work with you to design your own specific website accessibility policy, but we do not generally provide sample documents outside of the attorney-client relationship for use. That would be giving you legal advice. We can't be giving out documents for people to use. If for some reason they got sued, they came back to us and said, well, we used your policy. That's something that we can't hand out to folks, but certainly something we can help you with. How often is accessibility just one of many claims? Usually it's the only claim. It's almost never, because it's almost never one of a panoply of claims, because usually the visually impaired person has a very specific complaint with the property, and the website, which is not necessarily the same thing as any of the other issues that one might have with a physical premises. It's not unheard of, but not necessarily. It's certainly not the norm. If we have a third, and I'll let Martin grab one of these. Martin, if we have a third party managing our website and they confirm that they're compliant, how does ownership or management ensure that that representation is correct?
So if we have a third party managing the website, again, this is more of a drawing the corporate line type of question. The only guidance provided by the ADA is that it applies to owners, operators, lessors, and lessees to places of public accommodation. If you can somehow draw the line between you, defendant, to the website, then you're liable. I don't think you can escape liability by having a third party cooperate the website.
This goes to a follow-up question from Ashley: is if this can be effectuated through testing, could we provide examples of software testing that does this? Now, the answer to that question is, I think we mentioned the accessibility tools that Google has in its Chrome browser. That's an easy way to do a simple test. If you fail that, you're definitely going to fail the other tests. Passing that is only a small measure of security. The only real way to test is to go out and hire an experienced consultant, either internally or externally, who can actually do some testing of your website. all of the tools that are available commercially without a human being to back them up are only going to be so effective. You will get some measure of comfort, but it is not going to give you the level it's going to say, yes, I'm free from potentially being sued. If you have a hotline, do you need to make it TTY or otherwise available who cannot communicate by voice? Look, yes, obviously everything that you're offering as a service needs to have, it needs to be accessible. It doesn't need to be equal, but it needs to be accessible. So if you have, if you need to be able to make it accessible to what we call auxiliary aids, things like, the screen reader is an auxiliary aid, or a TTY, or Braille would be an example in the written book situation. So these are just ways to get more availability. So maybe just an email address and a voice hotline, that would probably be fine. I mean, again, that's more than most people do. And this becomes how much is overkill. If you're doing more than other people, you are making yourself less susceptible, but you're going to get a lot of traction out of that accessibility. Who would be the entity that would issue a certificate of compliance? Brandy, that would be a vendor. That there are vendors which will do that when you hire specific vendors for that purpose. Again, it's not a legal document. It's just something to show you that you've done stuff to prove your accessibility efforts. Any tips for the accessibility policy? Yeah, I would say you should talk to an attorney and a developer to get in concert to make sure that you've got your accessibility policy squared away. So our communities do not offer accessible units. Is the website required to comply with the ADA? Yes. I mean, look, there are two different things going on here. Usually the thing about accessible units, we're maybe talking about physically, wheelchair access, that type of thing. But if we're talking about visual disabilities, generally speaking, if you're covered by, you're offering something to the public, now if you're below the thresholds, if that's what we're talking about, then maybe not. But if you're out there into the public, the visual disability stuff are things you need to worry about. I mean, look, we say in our business, there's often a cost of being proven right as well. The cost of defending one of these lawsuits are almost always higher than the costs of compliance if compliance is in the primary instance. Once you get sued, it becomes a lot more expensive to comply, because built into the cost of that compliance is paying your lawyer and paying money to the other side's attorneys, in addition to the cost of compliance.
And we're probably conflating disabilities here. When you refer to offering accessible properties or units, you're probably referring to accessibility to wheelchair bound customers. Those units are probably accessible to blind people. And that's what we're talking about here with website accessibility.
Mm-hmm. So Greg asks, if you have an accessibility score out of 100, assuming that there's a level that everyone would agree in substantial compliance, no, really, there's not. I mean, that you're almost never going to be 100%, but it all is just a matter of risk mitigation. It also depends on which plaintiff's attorney you draw. Some of them are more reasonable than others. We've dealt with most of the big players, and some are easier to deal with than others, and that's a case-by-case analysis. Have we ever run into situations where both sides use the same software but cannot agree on on the accessibility? Absolutely. Yeah, that's almost every case. There's some level of disagreement among experts, because there is some amount of, I use my example of the eagle picture. What's sufficient? Is it just a bird? Is it an eagle, a bald eagle, a white bald eagle with brown feather? There are differing levels, and that is why the lack of regulation can be maddening. And I apologize to all of you for the government's inaction on this, but we say there's not much you can do about that other than write to your congressperson. That's the world in which we're living, and it's just one of risk mitigation. Will installing a widget make our sites ADA compliant? That's part of a suite of services that one can use to make one's website more compliant, but again, not going to be a cure-all. It's just one thing that one can use. Do you have experience with victims awareness? Yes. The short answer is yes. We have dealt with them in the past, and but it wouldn't. I don't think it would be appropriate to discuss particular litigants in the public forum. It's certainly something we can discuss offline. I believe that Aisha can answer questions about how one can access the materials later. Are there good templates or resources to find accessibility policies? Yeah, I mean, look, you can go to various websites, and big company websites will show you, they'll have little handicap, like wheelchair icons. A lot of them, you can click on those and see what they use, and you'll see that everyone is different. Some are really short, some are quite robust. It's just a matter of what's the tack each of them are taking. There are certainly good places to find one online. For a determination of what one's right for you, that's something you should discuss with your professionals. Oh, Martin, this one's you. You made the comment, $4,000 a pop under the UMRU Act. What did you mean by that?
That means $4,000 per offense. So in the website context, that means per visit to the website. I've had clients who were sued for $28,000, $32,000, denoting the number of times that the plaintiff claims to have visited the website in November and December and encountered barriers.
Right. So New York seats 500.
Yeah, it's between 100 and 500 in New York.
Yeah, but nobody sues for 100 if they can sue
Yeah.
for 500.
Hence the draw of California as a forum. It's very plaintiff friendly.
Yes. Do we have a list of providers, vendors? Yes. Well, a list. We have relationships with many of them, and we, depending on the needs of our clients, will discuss which vendors are the best for their particular situation. Again, it's a conversation we're happy to have offline with anyone who wants to do this. How do I obtain access to your website? Well, we are blankrome.com. I hope that we're accessible, but you can read all about the services we provide in this area. We're a full service national law firm. This is just one of the many things that we do, and feel free to look us up, of course. Sounds like you can be sued no matter how much time and effort. I need to tell this to my boss. Yes, Brian, you do. And it's one of these things where, yes, you can be sued, but there are a lot of things to do to reduce the risk and to reduce the impact. Vito's suggestion and a question about corporate structure is one, but it's also, that's a pretty complicated one. Another one is to make sure that you're just not a target. Another one is to reduce the number of websites that you have, reduce the offerings. There are strategies that your professionals can work with you to determine how to reduce. You don't want to be the whack-a-mole that keeps popping up to get hit.
Yeah, a lot of these plaintiffs lawyers go for the path of least resistance. So
Right.
if your website is accessible, I don't think 100% is achievable. I'm not sure anybody knows what that even means. But so long as you take some steps to make your website accessible, chances are you will repel a plaintiff when they run their tests on your website, because they go after the low-hanging fruit.
Yeah, we had a couple people asked about, I don't see it up here, about kiosks. Kiosks are also things, if you have kiosks in your facilities that allow people to log in and pay rent or do other things, or look at your apartment. Maybe you have something in the rental office or the public space people can log in, or almost like an ATM kind of a thing where people can look in and see the facility, take a virtual tour there. Yes, those need to be accessible. That's something that we can help with. Also needs to be physically accessible. The kiosk itself, if you're going to offer that, you need to make sure that it has wheelchair access as well. This is one of these overlap areas. Someone also asked about parking. Parking is certainly an ADA issue. Is certainly subject to an undue hardship analysis. There's also, parking becomes an issue with building codes, fire codes. It becomes there's a lot of overlaid regulatory frameworks that involve things like parking garages and parking spaces. And there are formulas in the ADA about how many accessible parking spaces one needs for a particular parking lot, depending on the number. It's basically, it depends on the number of parking spaces, how many spots are needed, but it's not just a straight arithmetic calculation. It's something like you need 4 plus the number 8 for every 100. I'm another one. It's more detailed than anyone I think wants to hear at this point of this call. But yes, there are rules for parking, and they are complicated. You should discuss them. If you're doing anything with parking, that's certainly something for your attorney, and your physical, your architect or your site developer. What are your thoughts on using a tiny widget to help with compliance? Anything you can do to help with compliance is a good idea. Again, all part of a menu of options for compliance.
The question of widgets goes to widgets versus manual auditing.
Oh yeah.
It depends on how complex your website is, and there are two schools of thought. Several vendors offer a widget-based solutions. These are software add-ons that go on to your existing website. Other companies offer strictly manual auditing, where a human being goes in, checks the code, and it's a much deeper dive. I mean, traditionally, human auditing is more effective.
And more expensive.
However, it's more expensive. So that's why Tony keeps reiterating that it's not a one size fits all solution.
Yeah. Portals and payments for residents, they have to have the same level of compliance. Well, as Brandy asked the question, and it's a good question. This goes back to the FHA. Do they need the same level? Well, it depends on what you would mean by need in that context. Obviously, your tenant portals are going to be accessed by a much lower number of people. But if you are going to the trouble of making your site accessible, your public site, you may as well include everything, because technically you could have an FHA problem with an intranet site. Most tenants are referred or see signage. Can you just have a simple, yes, I mean, Jeff, this goes to the question about Martin's law of unintended consequences, that people are removing websites and reducing content. That's another way to limit liability. Will you be compliant? I mean, again, devil's in the details, but if it's just like the name of the apartment building and a phone number and it says by appointment only, that's like the definition of the most minimalist website that there would be. And God forbid you got sued for that, it would be very easy to moot that defense by getting yourself compliant if for some reason there was like a picture that wasn't up to speed. All right, Aisha's going to talk about presentation. Okay, prospective tenants do an online search, name of buildings, and click on the website. Yeah, that's what I thought. So look, that just depends. If the website has a lot of information, once they follow that link, it's subject to the same things, subject to the same rules. Okay, so I think I'm through all the questions that we had. If anyone else has any additional questions, fire them off now, or feel free to reach out to us after the fact. Our information is there. Again, I'm Tony Mangione and my colleague Martin Kreslik. We're from Blank Rome. We do this. This is what we do. And there are other people at our firm who do this as well. That we've got folks across the country in our various offices, and we are ready, willing, and able to help you all out with whatever we didn't cover today and whatever your specific questions might be. So thank you for the opportunity to speak to you all today.